Miranda rights go into effect only when the arrestee is actually in custody and is being interrogated by a law enforcement officer. The arrestee must have been arrested or is not free to leave, and he must be questioned or interrogated by an officer. The officer must read the rights prior to questioning an arrestee who is in custody. If the rights were not read to an arrestee in custody, then any statement the arrestee makes to the officer in response cannot be admitted in trial. Therefore, before the Miranda rights kick in, the arrestee must be in custody and subject to interrogation by the officers. If the individual is being questioned by an officer when the individual is not in custody, the statements made by the individual can be used against him in his trial. For example, a driver is pulled over. The officer questions him about an odor of marijuana coming from his vehicle. If the driver states that he has marijuana in his vehicle, that statement can be used against him at his trial, even though his Miranda rights were not read to him. Another common example is when an individual is arrested and he claims the officer never read him his rights. However, the arrestee never speaks to the officer nor makes any statements. In that case, there are no statements to try to suppress from a trial. The lack of the officer to read the Miranda rights does not defeat the case. It can only potentially defeat statements made while in custody when the officer is questioning him. If you need a drug charge attorney for your drug charge in Louisiana, give us a call. We handle all types of drug charges anywhere in Louisiana.